Nigeria Apex Court, Supreme Court of Justices has ruled that the detained leader of the indigenous people of Biafra, Mazi Nnamdi Kanu, has case to answer, adding, there is no existing law in Nigeria that stops a court of law from entertaining trial of a suspect simply because the suspect's rights were violated by the prosecutor. The Supreme Court in its ruling on Friday set aside a judgment by the lower court that dismissed the terrorism charges against the leader of the indigenous people of Biafra, Nnamdi Kanu, in October 2022. According to Punch newspaper correspondent, the Apex Court held that the Court of Appeal was wrong and that the trial court couldn't try him because the prosecution violated his rights. Excerpts of the newspaper correspondent report reads thus below. In the judgment prepared by Justice Garba Mohammed, the court condemned the invasion of Kanu's residence, declaring it irresponsible. The court held that there is no law in the country stopping a trial based on the violation of the rights of a suspect. Mohammed said, if the police should destroy the house of a suspect to obtain exhibits, should that divest the court against entertaining the offense? His remedy should be the way of civil proceeding. Proceedings can't be stopped on account of the violation of the rights of the suspects. That is not our law for now. We decided not to go with the Court of Appeal. Though we condemn the violation of his rights, Nigeria must redeem its image and adhere to the rule of law. If a person has been granted bail, why did you invade his house? That is irresponsible. You shouldn't blame him for running. No legislation in the country strips the trial court of the jurisdiction to go ahead with Kanu's case despite the illegal action of the FG. The law must take its course. The Court of Appeal was wrong that the trial court couldn't try him. The appeal is allowed, and the cross appeal is dismissed. Kanu was first arrested in 2015 under the administration of former Nigerian President Muhammadu Buhari. He was subsequently granted bail in April 2017 and fled the country after an invasion of his home in Afara Uku, near Umuahia, Abia State, by the Nigerian military in September 2017. Kanu was re-arrested in Kenya and brought back to Nigeria in June 2021. He was arraigned before the Federal High Court in Abuja on 4 charges of treasonable felony, conspiracy to commit treasonable felony, illegal importation of radio equipment, and defamation of former President Muhammadu Buhari. The charges were later withdrawn by the former Attorney General of the Federation, Abubakar Malami, San, who replaced them with a fresh 14-count charge bordering on terrorism and membership in a proscribed group, among others. The court, however, reduced the charges to 7. The Court of Appeal sitting in Abuja on October 13, 2022, held that how Kanu was rendition to the country violated the country's extradition treaty and was also a breach of his fundamental human rights. The appellate court also struck out the terrorism charges filed against Kanu by the Nigerian government and ordered his release from the DSS facility. The FG, through the Office of the Attorney General of the Federation, appealed the court ruling and subsequently obtained an order staying the execution of the court judgment at the Supreme Court. Kanu, through his lawyers, filed an appeal against the stay of execution order at the Apex Court on November 3, 2022. Displeased by the verdict of the appellate court, the FG filed an appeal at the Supreme Court.
Then the court, thirdly, blamed the federal government and also condemned the brute force in which Mazi Nnamdi Kanu was abducted in Kenya and extraordinary remission to Nigeria. The court found the international law that condemned it noble, but courts likened the manner in which Nnamdi Kanu was in Kenya to a situation whereby evidence has gone for search in a premises. And the court said, though is condemnable and not covered. There are injectable materials found in those materials. That illegality do not affect those materials. The narrative becomes so the manner in which Mazi Nnamdi Kanu was abducted in Kenya and extraordinary remission to Nigeria is illegal and unconstitutional, but that will not affect the fact that Nigeria law has to take its place. What does it mean by Nigeria law taking its place? That since it's already in Nigeria, that we must go back to the Federal High Court to face the trial. That's something that will happen today. So of course you are aware that the federal government had before now 5-3 count charge, which were objected to his competence. Portion to which the court struck out, the Federal Court struck out 8 count and many some. So, and we appeal against it. Eventually, today, the court said we are going back to court for him to face that remaining 7 count charge. So, this is summary of what happened today in court. And it's not within our prerogative to condemn Supreme Court because this is final court of the land. So, we are going back to Federal High Court to follow the law. Thank you so much.
Thank you very much. Is there any date set for that?
No. We're expected to follow up because, of course, we allow the federal government time to do that at their own cost. Of course, by January ending, they are still there. So, I'm going to follow up to ensure that the date is given as quick as possible.